Hark, my people! I, Director William Hinman of the SEC, have come forth with a proclamation regarding digital assets. My personal opinion, of course. I do declare that from this day forward, Bitcoin, Ether, and Bitcoin and Ether shall be deemed not a security.
Welcome back to the Smoking Gun edition of Legal Briefs. I am Jeremy Hogan, the king of idioms today, and thank you to my brother-in-law, Dr. Joseph Geffen, for being our Moses voiceover. I think he absolutely nailed it, probably because he speaks Hebrew. In any case, there has been a lot of stuff going on in the Ripple versus SEC case, and give me 10 minutes and you are going to know what Ripple is trying to do, what the SEC is trying to do, and then the funnest part will be at the end because you are going to know all about the SEC smoking gun that we learned about this week. Just wait for it. Yes, the SEC was playing around with guns a little bit too much maybe in relation to Mr. Hinman's Ether is not a security speech, and we are going to discuss the heck out of that and what might be the Perry Mason smoking gun moment in this case. But there's a lot to get caught up on before we get there and talk about the smoking gun, so here's what's been going on for the last 2 weeks. First, Judge Netburn tells the parties on March 14, okay guys, it's time to wrap up discovery and move this case forward. Get together and tell me by March 23rd what else you need to do as far as discovery. Now, this is a fairly straightforward thing to do, and so of course the SEC seeks to delay it a little bit, and here's that motion, which was just filed a couple days ago on March 21, 2022. Looking at the bottom of the SEC's motion, you can see the summary, quote, accordingly, the SEC respectfully requests that the court allow this brief extension to determine whether any discovery is required, and if so, to submit a proposed schedule to this effect, close quote. And I have to admit, on its face, this makes a lot of sense from the SEC here, if you are talking about the individual defendants. But here, let me tell you what is actually going on as laid out by Ripple in its response to the SEC's motion to extend the March 23 deadline. Now this is from Ripple, and this is what really is going on here. Quote, the parties have also discussed a proposed schedule for the filing of summary judgment briefs and Daubert motions, with opening briefs due as early as May 22. The SEC has refused to commit to any schedule until after it reviews the individual defendants' answers. But even if the SEC were permitted to take discovery on the individual defendants and the individual defendants were to reciprocate, discovery has closed with respect to Ripple. Nothing should further delay Ripple from moving for summary judgment and demonstrating to the court that XRP is not a security. Close quote. So here's what Ripple is thinking and what it wants to do. Ripple wants to move forward quickly with summary judgment on the main issues in the case, whether XRP is a security and the fair notice defense. If Ripple can get those issues to summary judgment and win on either one of those issues, the case against Garlinghouse and Larson goes away. So Ripple is saying that since discovery involving those two issues is concluded, we can move forward with the Ripple case on one track, and in the meantime continue the discovery and other issues related to the individual defendants on another track. So they want to kind of bifurcate it and just get the Ripple issues moving forward. And that makes a lot of sense. Now the SEC, on the other hand, is trying to delay the case by saying that the Ripple case and the individual defendants' cases are all one case. And Ripple shouldn't be allowed to move forward until all discovery is concluded in regards to the individual defendants. Now, I'm not sure how the judge is going to resolve this issue, but if she agrees with Ripple, note that they suggested opening briefs on May 22 of this year, which would put us on schedule for a decision in late summer as expected. If the judge agrees with the SEC and won't allow briefs to be filed until all discovery is complete, well, a summer 2022 conclusion to this case is probably overly optimistic. We shall see. And how do we know that the SEC is playing a delay game, other than, of course, the multiple requests for extensions on everything? Well, all we have to do is take a look at what is going on with a simple expert report from the SEC and look at how heated things are getting as Ripple tries to call out the SEC for playing the delay game. And what you have to know about expert witnesses in this context is that in general, expert witnesses in a case have to submit a written report containing their opinions early on so that the other party can take a look at them, prepare, and depose the expert. This is Rule 26.2b of the federal rules, and it says it in pretty plain English for a federal rule. Quote, witnesses who must provide a written report. If the witness is one retained or specially employed to provide expert testimony, he or she must provide a written report. And then in subparagraph, I think I, it says, the report must contain a complete statement of all opinions the witness will express and the basis and reasons for them, close quote. It's very simple and straightforward. So, of course, what does the SEC do? It retains a Dr. Metz to prepare a report supporting its position that Ripple influences XRP's price. And then, when Ripple's expert refutes those opinions, and after all the expert depositions have already been taken, the SEC files what it calls an amendment to Dr. Metz's initial written report, which defends his report from Ripple's experts' attacks on it. So, of course, then Ripple moves to strike Dr. Metz's amended report for being filed late in violation of the rule. And how does the SEC respond to that? It says, Judge, not a big deal. Let's just have Ripple's experts do a rebuttal to the amended report. And we can redepose them on it later, and it's not a big deal. There's no deadlines right now, so there's no prejudice to Ripple. Let's all just chill and take our time with this thing. Which response was apparently the final straw for Ripple, because it responded with this, which is the most heated of any pleading to date. Looking at page 3, quote, defendants would face great prejudice if this litigation, which has placed their business in limbo, is further delayed by reopening discovery. Defendants would need to marshal additional resources to address Dr. Metz's newly filed report when the parties ought to instead be focused on summary judgment practice. And the SEC would again be rewarded by further delaying resolution of the ultimate issues in this case, close quote. And then in the last paragraph, quote, the SEC's decision to wait until after the very last deposition scheduled in this case to file Dr. Metz's new reply report necessitates sanctions. Ouch, yes, this is the first mention of sanctions, the S word, in litigation, and it's the harshest language that we've seen to date. But as the next few weeks unfold, remember that any fireworks or frustration are not stemming from the legal issues in the case. The conflict here is that Ripple is trying to move the case forward quickly, and the SEC, for whatever reason, is trying to delay it. But let's switch gears to something much funner now, because there was a smoking gun revealed in a pleading this week, and it's in relation to those pesky emails related to Mr. Bill Hinman's either is not a security speech, and whether Ripple gets copies of them. And yes, that is the infamous deliberative process privilege argument, and here is where we are with that. Now, as you may recall, Judge Netburn ruled long ago that those emails needed to be turned over by the SEC to Ripple, and the SEC has gone to extraordinary lengths in order to keep from turning them over. They've asked Judge Netburn to reconsider her order, which overruled the deliberative process privilege, and they also indicated that they intend to appeal Judge Netburn's ruling to Judge Torres, appeal it up, if she doesn't change her mind. Now, the legal position that the SEC has taken on this are so out of the normal in regards to this DPP issue that I concluded with this in a video I did about it about 2 months ago. Among the 60-some documents related to the Hinman speech, there could be something really, really bad for the SEC in there. And when I say bad, I mean something that really just destroys the SEC's case. Now, what that could be, I'm not exactly sure, but it'd have to be pretty bad in order to justify the legal gymnastics that the SEC have been playing on this issue. And you are going to be happy to hear that the January 2022 Jeremy, despite looking kind of tired, was spot on the money, and now we know what that really bad thing might be. Stay with me. So a couple of weeks ago, Judge Torres denied the SEC's motion to strike Ripple's fair notice defense, but at the same time, she denied Garlinghouse and Larson's motion to dismiss the lawsuit against both of them. Now, in denying the individual defendants' motion to dismiss the case against them, Judge Torres said that in order for the individual defendants to be found guilty, they must have knowledge of wrongdoing, and so the SEC took that part of the order and applied it to argue that the internal documents related to the Hinman speech are not relevant, and here it is in their motion. Looking at the bottom paragraph of page 2, quote, in light of Judge Torres' order, it is clear that the SEC's internal documents reflecting its staff's thinking about XRP, Bitcoin, Ether, or any other digital asset have no relevance to the individual defendant's scienter. Non-public SEC documents cannot shed any light on whether the individual defendants knew or consciously disregarded the facts that constitute Ripple's alleged violation, close quote. Now, I think this was a reasonable argument to make if you really need to keep those documents hidden. And as a bit of foreshadowing, notice that the SEC just said in that paragraph that the documents contain its staff's thoughts on whether XRP is a security. Yes, talking about XRP, but I'm getting ahead of myself. Let's first take a look at how the individual defendants responded in their reply brief. We are looking at the bottom of page 1 of the reply brief. Quote, "This court, in its January 13 opinion, rejected the SEC's contention that entry 9, containing communications related to the Hinman speech, was entitled to protection under the deliberative process privilege, DPP. The court's reasoning was straightforward." And here the brief quotes from the court's order. And the court said this, quote, "Although Hinman and the SEC admit that agency staff discussed his speech, it appears that this speech was merely peripheral to actual policy formation and not an essential link in the SEC's deliberative process with respect to Ether. Accordingly, emails concerning the speech or draft versions are neither pre-decisional nor deliberative agency documents entitled to protection," close quote. That's from the court. So, the individual defendant's counter-argument is that the SEC's relevance objection is inappropriate because the judge only ruled on the DPP issue, and on a motion for a reconsideration of a judge's order, you are limited to what the judge ruled on before. In other words, you can't come in at a motion for reconsideration and argue something completely new. That's not proper. And I think Ripple is correct in this. This relevance argument passed the SEC by a long time ago and can't be raised at this time. Which brings us to the smoking gun in the individual defendant's response brief, and it's on page 3 at the bottom, and here is what you've been waiting for. Quote, "The SEC should not be permitted to argue to the fact finder that Mr. Garlinghouse and Mr. Larson were reckless, not to recognize that XRP purchasers saw XRP as an investment in a common enterprise while concealing, potentially, that the SEC's own Director of Division of Corporation Finance had analyzed a substantially similar digital asset and maybe even XRP itself and concluded that it was not." You know, in the practice of law, there are not many Perry Mason moments, if you remember the TV show. Usually cases are won or lost by meticulous and somewhat boring extraction of testimony from somewhat boring witnesses. This is not the usual. Look at what Attorney Solomon is suggesting in those emails the SEC is so desperately trying not to give Ripple. Now first, he states that potentially the SEC Division of Corporate Finance had analyzed a very similar digital asset and concluded that it was not a security. Now the first asset that came to my mind was XLM, and if that analysis is in these documents, that is of course very helpful. But then Solomon goes on and says, in kind of a throwaway parentheses type thing, and maybe even XRP itself, by which he is suggesting, of course, that in those documents is something analyzing XRP and concluding that XRP is not a security. And this document was created over 2 years before the lawsuit was filed by the SEC alleging that XRP is a security. Yes, that would be very, very bad for the SEC. It's a little more than a smoking gun. It's more like this. A smoking Rambo. Now, is it possible that Attorney Solomon is just bluffing or making things up? Yes, it's possible, but that type of musing is not something that a lawyer would lightly put into a pleading. For example, you wouldn't suggest to the court that you need to obtain emails from a murder victim because they might show that the emails might show that the victim committed suicide. You just wouldn't do that unless you had a pretty good idea that there was something in those emails that suggested that. And how bad would an SEC document stating that XRP is not a security be for the SEC? Well, Attorney John Deaton, representing 66,000 XRP holders, now thinks that if the SEC is forced to turn those documents over, they will settle the case. And here he is saying it on Twitter. Quote, "Why the Hinman speech email equals settlement," close quote. He gets to the point. And then later in his tweet he concludes, quote, "Hence, if we get a ruling that they must be turned over, I believe the case settles within 60 to 90 days from that decision, or possibly sooner," close quote. And there you have it. And now that we have successfully moved past the motion to strike the fair notice defense, now you know what the most important legal issue is moving forward, and that is, will the judges finally force the SEC to turn over those documents? And the answer to that question, whether they have to or will be forced to turn over the documents, the answer is 100% for sure. And now that you know the answer, the way that will play out is Judge Netburn will rule on the pending motion to reconsider her prior ruling. Those are fully briefed now and she can rule on them. Now if she sticks with her prior DPP ruling, then the SEC has already said that it will appeal that ruling to Judge Torres. Now that will take at least a month to get in front of her. Then the key inflection point here is whether the SEC then tries to appeal Judge Torres' decision to an appellate court. Now if they did, it could take months to get an appellate decision, which makes me think that the SEC will try to appeal it, because it can't give up those documents. But the thing I want you to know is that an appeal of the DPP decision would not be automatically granted. This DPP ruling is called an interlocutory decision, meaning it's not a decision that ends the case like a summary judgment or a trial verdict. The thing to keep in mind is if you see the SEC file an appeal in the Ripple case on the DPP decision, it's probably not appealable. In federal court, it's hard to get an appeal accepted. First, Judge Torres herself would have to give the SEC permission to take it up to an appellate court, and then the appellate court would take a look at the issue, and it would also have to decide to accept it. I don't find it likely here in this case with this DPP issue, but I think the SEC will try anyways because it delays the case further, and as we know, delay is the name of the game for our SEC. Remember, over the next couple weeks, Ripple will try and get the case scheduled for summary judgment this summer. The SEC will try to delay that, and the SEC will do anything not to hand over those Hinman speech-related documents. Those three positions will color everything that happens over the coming weeks, and now you know what's going on. Thanks for watching.